Shalom. Today I'm going to be doing a follow-up video to a previous video I did talking about wellness messiahs in the Black conscious community and how certain individuals and personalities reach the pinnacle of messiahship within the minds and hearts of people in the Black community. And most of these individuals have not had any scientific research or proven any of the claims that they make. And if you look at most of the products they provide, none of them actually claim to diagnose, treat, prevent any diseases in human beings. All they are is herbs and concoctions. Some can have benefit. Herbs do have benefits in the body, but to claim that they actually cure and prevent and that you can diagnose diseases with these services that they have is fraudulent and misleading to a lot of people. And why I'm doing this is because a lot of people are desperate for treatment. I've been in situations myself where I've looked for holistic approaches to certain things I've been dealing with. And to be misled and to be deceived when you're at a very vulnerable point in your life, I think is very low level and wicked, honestly. That's why I'm talking about this. I want people to be informed and make the best decision given all the information available. Now today I'm going to be going over the court documents for the court case that a lot of Dr. Sebi's disciples quote and claim proves that he has cured diseases like HIV, herpes, sickle cell, lupus, and other diseases. Well, contrary to their repeating and misinformation, the court documents do not state that. The court documents bring a case against Dr. Sebi among some other people, and I'll go through that. And it pretty much states that they were making fraudulent claims, and they posted in a particular newspaper an article stating that they could cure herpes, HIV, and all these different things. Turns out that they actually settled this case and were ordered by the court to post 3 articles or 3 ads to really retract what they had already put out about curing HIV and AIDS. They never talk about that they were ordered to put advertisements in the paper that said that they could not do that. They don't mention that, any other people today. They also don't say that there was a settlement and that they couldn't fight the case because they would have incurred lots of legal costs. Okay, excuse me. So let's take a look at this document. You can go online and find this, and this is www.casewatch.org/AG/NY/consent_1988.pdf, and this is the actual recorded record. You can find this on file in the annals of the New York State Supreme Court, and this just states the authority, which is the court of the state of New York, and has the address and the date that this was recorded, 7th day of June 1988. And this is the judge presiding, the Honorable Kenneth Shorter. This is the Attorney General of the state bringing the case against Dr. Sebi and many others. They're called the petitioners. You'll see that term further in the document. So the petitioners is going to be pretty much the prosecution, so to speak. And then here are the respondents, or the defendants, so to speak. The Ogun Herbal Research Institute, Usha Herbal Research Institute, Alfredo Bowman, aka Dr. Sebi, Annette Thomas, Ma Bowman, and Fig Tree Products Company. And this is, you can find this is a Freedom of Information request you can make if you are interested in pulling up the document, and index number 40396/87. So this is the document, and it shows who's involved in the case. Okay, now we're going to go down. This is kind of just the introduction about the individuals involved in the case. We're going to go into the narrative about what was the actual charges and what was the resolution and the conclusion of the case. So this is just some basic information. Trial having commenced the 1st of July 1987 before the Honorable Kenneth Shorter. Testimony had been given through these dates, and the trial having adjourned until the 4th of September, and then further adjourned, and appearance having been made for petitioners, which is the prosecution, so to speak, And then you go further, and the respondents, Ugo and Herbal Research, Dr. Sebi, so on and so forth. Okay, now let's take a little bit. You can go online and read this. It's long, so I'm trying not to read all of it, but I just want to hit some key points. So it talks about the law that he was actually brought into court under, it appearing that petitioners, the people of the state of New York, commenced this proceeding pursuant New York Executive Law, Section 6212. So this is what he was actually charged under. Section 6212, against the above named respondents, to enjoin alleged fraudulent and illegal acts or practices in which respondents are alleged to have been engaged, and it appearing that respondents, without admitting that they are or have been engaged in any alleged fraudulent or illegal acts or practices, are desirous of resolving this matter without further trial or adjudication or any issue of fact or law herein, in order to avoid incurring further substantial costs, and go down some, necessary to defend themselves against petitioners' allegations. Okay, so that pretty much means that they're the respondents, which is Dr. Sebi's people, were charged under this particular law, and they are not admitting to doing anything illegal, but they choose to resolve the case because they can't afford the substantial cost of the case, but they are wanting to resolve the case so that they don't incur any more legal costs without admitting fault. But you'll see that the stipulations of this agreement require that they do specific things regarding the ad that they placed in the newspaper. They're going to have to retract it and put some other things in. They're going to have to give people's money back. They don't ever talk about this in the conscious community, that he had to concede and do this. Now, does him having to stop the case because of legal costs mean that he's guilty? Not necessarily, but we do see that the case and the terms involved in the case were not reported correctly to the public. We were told that he won, he brought all these witnesses, and the case was won and thrown out. That's not what this says. So let's keep going. It appearing that nothing in this consent judgment shall prohibit respondents from engaging in any lawful activities. So they still have the right to practice whatever they're doing as long as it's lawful. You can give people herbs, but you cannot say that you can prevent, diagnose, and treat diseases unless you have a license, unless you are a doctor in the state of New York. So that's really where he's being brought in. But this particular part of the document saying he wants to end the proceedings because they can't financially defend themselves. Now, therefore, upon consent of the petitioners and respondents and their respective attorneys, and on motion of the Attorney General of New York and assistant, okay, this is just the people involved, okay, of counsel, it is ordered and decreed that whereas petitioners and respondents Annette Thomas have entered into separate settlement. So Annette Thomas, who was mentioned earlier, she's going into a separate settlement. So this further decree is only going to apply to the other respondents. She has separated, and this doesn't apply to her. Okay, the claims alleged against the respondent Annette Thomas shall be and hereby are severed and are not a part of this judgment and order. It is further ordered, adjudged, and decreed that this judgment order shall extend to Ugun and the individuals we first saw, minus Annette Thomas. Okay, it applies to Dr. Sebi, his USHA Research Institute, principals, officers, directors, employees, agents, successors, heirs, and assigns, and Alfredo Bowman. Sorry, I can't read that. Their successors, heirs, assigns. So all this applies to everybody involved with him in this research center, that they will have to follow what this court orders. Okay? Ordered, adjudged, and decreed that respondents are permanently enjoined from engaging in any fraudulent, deceptive, or illegal acts or practices, including but not limited to. So the court pretty much found that they, or accused them of practicing fraudulent, deceptive, or illegal acts of practices. Okay, and we're going to see these stipulations, including but not limited to what these different bullets will be. claiming orally or in writing, directly or by implication, that respondents, their services, or their products can cure, mitigate, or in any way relieve or alter the course of AIDS, herpes, leukemia, sickle cell anemia, lupus, or any other human disease, pain, injury, deformity, or physical condition. Number 2, distributing or publishing any advertisements, brochures, or any printed matter, broadcasting, which claims directly or by implication that respondents, their services, or products can cure, pretty much the same thing, saying you can't cure any diseases. 3, diagnosing, treating, or prescribing. Now, if you go to my first video, I talked about what supplements and herbal medicine can and cannot claim. They cannot claim to cure, prevent, diagnose diseases, and this pretty much goes along with the FDA requirements for supplements. 4, they cannot sell or otherwise distribute any products which are labeled or otherwise advertised, which claims that the product's ability, either alone or in combination with other products or procedures, to aid in the diagnosis, cure, mitigation, treatment, okay, same thing. 5, selling or otherwise distributing any products which are labeled or advertised with claims regarding the product's ability to affect the structure or any function of the body of a human or other animals. Okay, so this is what they required them to do. They have to, restitution, they have to put within 60 days of the court's judgment, respondent shall place 3 advertisements in New York, Amsterdam News offering a full refund to any consumer who claims he or she was or is dissatisfied with any of the respondent's products or services. The first advertisement shall be published within 30 days. Okay, you can read that a little bit closer. Okay, publication shall be published at least 2 weeks apart from either of the 2 advertisements. Each advertisement shall be in at least 15-point type and shall state the following: anyone dissatisfied with any of the services or products of Usha Herbal Research Institute or Alfredo Bowman, aka Dr. Sebi, can apply for a full refund. Requests must be made no later than 6 months from the date of the entry of this consent judgment in writing and sent to the New York State Attorney General at that address. So pretty much they're issuing refunds. Now, would you be able to give a refund if the claims of the product were valid, or they actually did what they said they did, or there was proof? Most likely not. He probably wasn't able to provide sufficient proof that the claims that he had made were actually truthful. Okay? Besides that, the law states a supplement's not supposed to be able to claim that without being researched first. So you can't just claim things with no proof. Okay? That's pretty much what it's stating. And they don't talk about that he had to put this ad out. They didn't talk about that he had to pretty much settle because he couldn't afford the court fees. Okay? So you can keep going, and I'm not going to read all this, but I want you to just look at the inconsistencies between what has been told to us about Dr. Sebi's court cases and what is actually recorded. We find out is a lot of really ambiguity as to this. None of this talks about whether the products and services were actually truthful. It just states that he made claims that he cannot prove or were illegal to make. Doesn't say that the judge started to follow Dr. Sebi. It doesn't say that he had 60 or 70 witnesses come in and prove that they were cured of diseases. Okay? Even though he wasn't charged or anything, he still had to retract what he had claimed. And he still, to this day, and the people who work for him, even though he's passed away, cannot claim that he cures, prevents, or treats any diseases. And you see, if you see his bottles, I have some of his bottles. His bottles don't claim any of that. They say not approved by the FDA, not evaluated by the FDA, and